How much authority do courts have to resolve problems between corporate shareholders? The court considered that question in Hall v. Hall. Edward Hall and Harry Hall each owned half the shares of Musselman and Hall Contractors, a Missouri corporation. Both men were the corporation's only directors. Edward died in September 1969. His widow, Margaret Hall, became successor to his shares and executor of his estate. Harry then appointed his own wife, Florence Hall, as director to fill the vacancy caused by Edward's death. Harry and Florence appointed themselves president and vice president of the corporation. They didn't call a required annual meeting, so Margaret called an annual meeting for May 1970 as set forth in the bylaws. Margaret appeared at the corporation's registered office for the meeting and to vote her shares, but Harry failed to attend. Because the bylaws required a majority of shares to achieve a quorum, no business could be conducted. Margaret adjourned the annual meeting from week to week. In August, Harry and Florence, who remained in control of the corporation, held a special directors meeting and voted to sell 3,000 unissued shares for $10 a share. Margaret sought to exercise her preemptive right to buy half the additional shares, but contended that the issue was invalid because the directors approving the sale held office unlawfully. Margaret petitioned the state court for an injunction compelling Harry to attend a shareholders meeting. The trial court dismissed the petition, and Margaret appealed to the Missouri Court of Appeals.